The workshop was titled, "Don't Ask Us Why, We'll Tell You How," which is kind of cryptic. Does anybody know why we came up with that title? Okay, well, our experience is that sometimes when there's change, people spend up a lot of energy asking, particularly in relation to new legislation, well, why did they do that? Or why didn't they do that? And that's rubbish. But actually, the time for debate about this act is past, because it's law now. We're going to be working with it. So our job in the training units is really to support you as panel members to help and support you to operate and to practice under the new act. So, the time for debate is past. This is what we have to work with, and we have to try and work with it as best we can. In this workshop, I'm going to highlight some of the things that have changed, and you'll have the opportunity to put some of these into practice. As part of the development of the rules, we did 3 road testing events. They helped with the development of the rules. They also informed us about issues in relation to training. They were able to flag up the areas that we thought would be fairly straightforward, but I say that with reservation, because I'm sure you all know that when you go into a hearing and say that's going to be straightforward, then it all goes pear-shaped. So we've met what we think will be straightforward, and we've also been able to highlight the areas that we think there might be a bit more difficulty around. And if we have time today, we didn't have time in the previous workshop, but if we have time in this one, we could do a mini road test, okay? But one word of caution. I don't want you going away from this workshop thinking that you now know everything there is to know about the 2011 Act, and you don't really need to go to training on it. This is really what it says. It's a sneak preview of some of the things that have changed. But before I talk about the Act, I want to tell you a bit about the training that we've planned, because we've put a lot of thought over a considerable length of time into the planning of the conversion training. So it's in 3 parts. We are developing, in fact it's quite exciting, it's being built as we speak, an e-learning package which you will receive in advance of the face-to-face training. For those that don't do computers, we've also developed a booklet which is a guide to the 2011 Act. So you either have the e-learning package or you can read the booklet. I would recommend the e-learning package because it's a much more interesting way of taking in information. But the booklet has two purposes, because as well as being the advanced reading for the training, it also hopefully will be something that you can carry around with you in the early days of implementation of the Act, because it's going to be A5 shaped, so it'll be easy to pop into a handbag, or I'm not sure where the gentlemen are going to put it, but carry around with you so that you can refer to it. So you'll do the e-learning package or read the booklet to give you information to come along to the training. And then the training will be 1 single day. But by doing this advanced work, it means what we will do on the day is to consolidate your learning, and you'll do a lot of practice of what you've actually read in advance. It helps us to make the best use that we can of the day's training. And we didn't want to make the training any more than 1 day, because then it gets very complicated. But after the single day, we will be offering you top-up sessions. The single day's training is compulsory, mandatory, whatever you want to call it. The top-up sessions are optional, but hopefully you will take advantage of them to come along and revisit maybe areas that you're not sure about, or to clarify any issues. You might go away and think, oh, actually, I wasn't quite sure about that. So it gives you the opportunity to come back and revisit the Act. Our training starts in March. If you do your training early in March, you're going to continue to operate under the 95 Act until the magical 24th of June. So, you know, it is going to be quite confusing. So hopefully these top-up sessions nearer to the implementation of the Act will give you the opportunity to refresh. So that is the plans for training. Before I go on to talk about what's in some of the things that are in the Act, can I just say that reiterate what Robert Marshall actually said in the plenary session, that your fundamental role as a panel member is not going to change. Your primary role is still going to be to make decisions in the best interest of children and give reasons for those decisions. The overarching principles within the Act, within the system, remain unchanged. You still have to take account of the welfare of the child, the views of the child, and the no order principle. In fact, the views of the child is strengthened in quite a lot of ways in the new Act by some of the provisions. For example, the chairing member, which the equivalent of the chairperson, is going to have to check with the child at the beginning of the hearing that their views are actually represented properly in the reports. And your justification for imposing compulsory measures remain the same. Does the child need protection, treatment, control, guidance, or a combination of those things? So your basic role isn't changing very much at all. So what does change? As you heard earlier, there's a national structure, area support teams. I'm not going to talk about those today because thankfully everybody smiles because they're being covered elsewhere. There's a difference in terminology, which I will talk about a bit in a minute. The grounds for referral. There are some changes to the grounds for referral. There's some new ones. Some have disappeared. Solvent abuse glue sniffing has gone, and exposed to moral danger has gone. Everybody says thank goodness. And there are some new grounds which actually reflect much better society today. So there's a ground relating to a child having a close connection with somebody who has committed domestic abuse. There's a ground which I think may be used in some cases to avoid using offence grounds, and that is that the child may harm himself or someone else through their behaviour. But actually, a panel member's role in relation to grounds for referral doesn't change at all. Your role will still be to explain the grounds that you have and then to check whether the child and relevant person understand and accept them. There are new orders, or at least new names for orders. There's a change to the legal representation provisions, and there's changes to some of the procedures which we'll look at as we go through this workshop. Terminology. There's some phrases here that you'll be very familiar to you which are changing. A supervision requirement becomes a compulsory supervision order. Place of safety warrant becomes, and this is a real mouthful, an interim compulsory supervision order. An ICSO, in other words. Okay, I'm going to talk about those a bit more in a minute. A business meeting transfers to a pre-hearing panel, and I'm going to talk about pre-hearing panels because they don't just replace business meetings, they actually extend the provisions of business meetings. And continue the hearing becomes defer the decision. And I think that's actually good because the word continue, isn't it?
You have to explain it every time you use it.
And you use it in different contexts. You continue the hearing, or continue with the hearing, or continue the supervision requirement. So I think that is actually quite good. There's three main decisions that you will be able to make as a hearing. You can make a compulsory supervision order, which is really just the same as a supervision requirement. Or you could make an interim compulsory supervision order, an ICSO, which is not the same as a place of safety warrant. Does anybody know how it's different? No? Well, you can have an ICSO with the child remaining at home. Mm-hmm. So you can have an interim compulsory supervision order which doesn't, a place of safety warrant meant the child was removed from home. Mm-hmm. You can have an interim compulsory supervision order with the child remaining at home, or with it being in a named place, or in a place of safety. but you can only issue it as a matter of urgent necessity. So you can't just think, well, it would be quite nice to get a bit of work going with this child, so we'll just make an ICSO so the social work can get working with them. That's not fair, particularly if the grounds haven't been established. But if there's a matter of urgency, you could... Sorry, Michaela.
Oh, I was just going to ask, does it still just last the same period of time?
It still lasts...
That's not changing?
That's not changing. 22 days with a maximum of 66 days up before proof. After proof, you can just keep issuing them. But you might, for example, I'm trying to think of an example where you might leave the child at home. It might be that the child has been the victim of an offence, the actual perpetrator of the offence has moved out, but you want to make sure that that child's not going to have any contact with them, so you could make an ICSO with a condition of no contact with whoever. There is another decision, and that's an interim variation of a compulsory supervision order. Now, this, at the moment, you've got a child on a supervision requirement, they come to a hearing and you need to do something in relation to interim care. You might be continuing, but you don't think the child's safe at home, or the child needs to move to secure or somewhere on an emergency basis. You would make a place of safety warrant, yeah? You don't now. What you would do, you would make an interim variation of the compulsory supervision order. So you would vary it on a interim basis for a maximum of 22 days. So what this means is actually that the child will never be subject to more than one order at a time. So at the moment, you could have a child subject to a supervision requirement with a place of safety. That won't happen anymore. There will just be the one order. Does that make sense?
Yeah.
Good.